Most people wait until it's too late. A lawsuit is filed. A divorce is underway. A creditor is knocking on the door. And suddenly, they're scrambling to protect what they spent years building. But here's the truth. By the time a crisis hits, most of your legal options are already off the table. The smart move? Prepare now. Because asset protection isn't about reacting. It's about planning. In this video, we're breaking down exactly how to legally protect your assets before a crisis hits. Whether it's your home, your business, your retirement savings, or your investments, we'll show you how to safeguard what you've earned legally, effectively, and before it's too late. Let's start with the basics. What does it mean to protect your assets legally? Legal asset protection is the use of strategies, structures, and laws to prevent your personal or business assets from being taken in a lawsuit, bankruptcy, divorce, or other financial crisis. It's completely legal, and when done right, it can mean the difference between financial survival and total loss. So how do you do it? The first step is knowing what you're protecting. Your home, your bank accounts, your vehicles, your investments, your business, your intellectual property, even your future income. If it's in your name, it could be vulnerable. Next, you need to create separation between you and those assets. Legally speaking, the more distance you put between yourself and your wealth, the harder it becomes for others to get to it. Let's start with business owners. If you're running a business as a sole proprietor, stop immediately. Every dollar you earn and everything you own is at risk. A single lawsuit could wipe you out. The solution is to form a limited liability company or corporation. An LLC or a corporation creates a legal entity that separates your business activities from your personal finances. If someone sues your business, they can only go after business assets. Not your home, not your car, not your savings. But it only works if you treat it like a real business. That means keeping separate bank accounts, documenting your operations, and avoiding personal use of business funds. Fail to follow these rules, and a court can pierce the corporate veil, holding you personally liable anyway. Now, let's talk about trusts. Trusts are powerful tools that can legally move ownership of your assets into a structure you control, but don't technically own. A revocable living trust is often used in estate planning. It can help your heirs avoid probate, but it doesn't protect your assets from lawsuits or creditors because you still control everything. For true protection, you need an irrevocable trust. Once you move assets into an irrevocable trust, you no longer own them, the trust does. And if you no longer own them, your creditors can't take them. But here's the trade-off. Because you don't own them, you also can't use them freely. So you have to plan carefully. Then there's the Domestic Asset Protection Trust, or DAPT. These are allowed in certain U.S. states and let you place your assets in a trust that protects them from future creditors, even though you still benefit from them. Not every state recognizes DAPTs, and the laws are complex, so this is definitely something you want to discuss with a legal expert. Now, let's move to your home. In many states, your primary residence is protected, at least partially, under what's called a homestead exemption. In Florida and Texas, for example, that protection is extremely generous. In other states, it might only be a few $1,000s. Understanding your state's laws helps you decide whether to leave your home in your name or transfer it to a trust or other structure. Next, consider retirement accounts. Most 401(k)s and IRAs are protected from creditors under federal and state laws. This means they're generally safe even in bankruptcy. But be careful. If you withdraw funds early, they may become exposed. And inherited retirement accounts don't always have the same level of protection. Another tool you shouldn't overlook is insurance. Liability insurance, umbrella coverage, professional indemnity insurance. These are your first lines of defense. If someone slips and falls on your property or sues you for professional malpractice, insurance is what kicks in to protect your personal assets. Umbrella insurance is especially valuable. It provides an extra layer of coverage once your standard policies are exhausted. It's affordable and can cover millions of dollars in liability. Don't skip it. Now, let's talk relationships. One of the most overlooked threats to your assets is divorce. If you're getting married or already married, and you have substantial assets, a prenuptial or post-nuptial agreement can protect your wealth. These agreements can outline exactly what happens to property, business interests, and accounts if the marriage ends. Courts enforce these documents when they're created fairly and transparently. And while we're on the topic of personal changes, let's address inheritance. If you expect to receive a large inheritance, consider placing it in a trust rather than accepting it directly. A properly structured trust can shield that money from your personal liabilities and even keep it safe for future generations. One area people often ask about is offshore protection. Some individuals place assets in foreign trusts or accounts for privacy and legal shelter. While this can be effective, it's highly regulated. You must report foreign accounts to the IRS, and failing to do so can lead to severe penalties. Offshore protection isn't illegal, but it must be done transparently, with the help of professionals, and for legitimate reasons. Now let's talk about what not to do. Don't try to transfer all your assets to your brother or spouse the moment you get sued. That's called a fraudulent transfer. Courts can reverse these moves and penalize you further. The same goes for selling assets for below market value to avoid creditors. If it looks like you're trying to game the system, you'll be treated accordingly. That's why timing is everything. Asset protection only works when it's done before any threat appears on the horizon. Once you're in a lawsuit or under investigation, your hands are tied. Judges will look at your past actions, not your intentions. That's why now is the time to act. Finally, asset protection isn't a DIY project. You need a team, an attorney who specializes in asset protection and estate law, a tax professional who understands how different structures affect your financial picture, possibly even a financial advisor who can help you organize and prioritize your goals. They'll help you create a comprehensive plan, one that keeps your name off public records, limits exposure, and ensures your family and legacy are protected, no matter what happens. So what's the takeaway? Don't wait for a crisis to hit. Lawsuits, divorces, financial downturns, they don't give you a warning, and once they arrive, you'll wish you had prepared. Asset protection isn't about fear. It's about control. It's about making sure that everything you've worked hard for doesn't disappear overnight because you didn't plan ahead. Take action now, because once the storm comes, it's already too late to build the shelter.